The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. This is Jennifer Schaus, and welcome to our government contracting webinar series. We are in week number 8 of 10 weeks of government contracting webinars. Today, we're joined by Andy Mirsky, who's going to be discussing GDPR and the EU's data privacy laws. The full schedule of webinars is on our website under the webinar section. All of the recordings will be listed there as well below the schedule, and they're typically listed the same day later in the afternoon. A little bit about us. We're based in downtown DC, providing various services for contractors ranging from capability statements, 8A certification, contract compliance, GSA schedules, and more. Throughout the year, we do host networking events and seminars. You can find them on our website under the event section, or if you sign up for our newsletter, which now reaches about 11,000 contractors, you can stay abreast of other events that we've got coming as well. This slide touches on my background, but more importantly, I'd rather dig into our topic today and let Andy kind of take over. So Andy, thanks again for joining us today. Excited to hear your presentation, and I'll give the floor over to you now.
Hi, Jennifer. Thank you. Thanks for inviting me. And hello, everybody. I am, in fact, Andy Mirsky, and as the slide says, I am my firm is M Street Legal. I'm based here in Washington, D.C. I also have an office in New York. I founded the firm about 13 years ago, but I have 24 years experience practicing various aspects of business law with a focus on business advisory and transactional work for technology companies, media, and other publishing companies, and particularly digital publishing, which brought me into the sphere of the topic area I'm discussing today, privacy and data security, because I do a lot of work on contracts, intellectual property, and privacy and data security. And in the data security and privacy world, there is no bigger issue today than the GDPR, which is the acronym for it's an EU law, and it's an acronym for Global Data Privacy Regulation. And I'm here today in the world of U.S. federal government contracting to discuss the new law, and its applicability to the world of U.S. federal government contractors. As you may see on the slide there, the GDPR is a law. It was enacted a few years ago, but there's an implementation period which officially ends next May 2018, at which time the enforcement mechanisms will be in place. So there's a ramp up to enforcement and implementation, which ends next May. It is a law that replaces a previous law from going back to 1995, which was called the EU Data Protection Directive, which many of you may be familiar with, which was not so much a law, but it's called a directive because it was a guidance essentially from the broader EU collective to the individual countries to adopt laws to their individual country-specific jurisdictions. And that was fine, being that it was enacted in 1995. The world has changed dramatically, especially in the privacy world. And as a result of that, and as a result of many other things, both legal, political, business-wise and otherwise, this new regulation, the GDPR, was enacted a few years ago to replace the 1995 law, which is where we are today. Next slide, Jennifer. There's a couple. I will get to the obvious. One of the first obvious questions is how this applies to the world of U.S. federal government contractors. In just a second, I just want to say one or two quick things about the differences between today's law and the law it is replacing, which is the biggest one, of being that that it has much broader jurisdictional scope. And by that I mean the previous law, which is actually the current law, the directive, doesn't technically apply to you unless you are actually in the EU. That's a gross simplification, but it's a practical reality. That has changed dramatically. I'll get to that in a minute. The new data security requirements under the new law are much broader and much more comprehensive. As I said, the current law is a directive, the new law is a regulation, and it is applying European-wide, but also worldwide to anybody touching on European data. I'll get to that in a minute. And not necessarily most importantly, but a very scary item is it has very large penalties and strong enforcement mechanisms, which gets a lot of people's attention, not surprisingly. Next slide, please. So I just want to say quickly what, I'm only going to talk for 15 or 20 minutes on this, and so I don't want to scare everybody saying that I'm going to go into incredible detail here, but I will say a couple things. What this presentation is, this is an introduction to the new law and how it applies to you as a U.S. federal government contractor, an alert from me to you on how this law could apply to your world. I do want to be clear, this presentation is not just simply due to the shortness of it and the scope. It can't be a compliance guide. But I do want to, if there are issues, many of you are probably already talking to your legal counsel about these and related issues if they relate to you. But I do want to encourage you to bring these questions up to your legal counsel about specific actions you should take over the next 9 months or so to implement this if it applies to you. I do list at the end of this slide deck a number of very good compliance resources. There's many out there on the web you'll find. Okay, next, please. How does this apply to U.S. federal government contractors? How could this possibly apply to me? Hey, I only do business with the U.S. government, right? So it doesn't seem obvious to me that I, as a U.S. federal government contractor, would be covered. Well, let's get to that. Next slide, please. There is, just to be clear, there's nothing unique to U.S. federal government contractors making them subject to the GDPR, or is that really the case? Yes and no, and I'll get to that. That's a very big takeaway from this, and I'll get to that why on that in just a second. But I do want to be clear. As I said, the GDPR is a new law. It has much broader global jurisdiction than the current law. And it applies to any organization that processes or stores personal data of EU citizens, or any organization that monitors behavior of EU citizens. I'm not going to go into a great detail of what those terms mean, but I will say a couple things. It's regardless of whether you have an office or a physical presence in the EU. That is a big change. Processing or storing activities, if you're doing them, they don't have to take place in the EU in order for you to be fall under the umbrella of this, and you do not have to be physically operating in the EU to be covered. Just want to say something very quickly. What we're referring to when we say processes, it's any operate. This is actually the definition from the law. Any operation or set of operations which is performed on personal data or on sets of personal data, such as collection, recording, organization, structuring, storage, on and on and on. It covers a lot of things. One of my many takeaways to you from this will be if you touch on the world of EU data, there's a very good chance you're covered. I had a client ask me the other day about this. Well, sometimes all we do is collect the data. We don't actually use it for anything. We don't process it. We don't take action based on it. But the fact of collecting means you store it. And if you store it, you're governed by the law. Okay, next please. The type of data that's covered, personal data, that's what we're talking about. If you're not handling personal data, you're not covered by this. What is personal data? This has gotten a lot of attention in the news over the past few years because the U.S. definition and both at the federal level and the states has been much less broad than the European definition. So, for example, the EU now explicitly includes IP addresses, application user IDs, GPS data, cookies, biometric data, email addresses. Some of that's also obviously already covered in the United States and most federal and state laws, but until very recently, IP addresses certainly was not. That was deemed not personal data. It is now for purposes of the EU. And I will say this, one other thing, the question of what type of data. Personal data is any information relating to an identified or identifiable natural person. And that distinction is very important. It doesn't necessarily have to, by itself, identify the person. If it can be used with other data to match up to an identified person, then it falls under the category of personal data, and then it falls under the category of this law. Next slide, please. So you've come to this point, GDPR might apply to you. Okay, so what? What's the big deal? Well, the big deal is it's got a lot of compliance items. That's obviously a lot of work. But it's, as I said previously, it's also got huge penalties. Two types of penalties, up to 2% or 4% of global annual revenues of your business, up to, for non-serious breaches, up to 10 million euros. For serious breaches, up to 20 million euros. These are large penalties, and they, as I said, there have been no enforcement actions on this because the enforcement period doesn't kick in until next May. But this is what's out there for enforcement. Okay, next slide, please. This is my quick break slide to just kind of throw in the fact of, okay, so there's a lot of scary stuff, a lot of compliance stuff, which I'll touch on. There's a lot of penalties. What do you need to do? Is this a hair on fire? Is your hair on fire moment? No, it's not. It's just something you need to be aware of and ask questions of your advisors and make sure you're attentive to it. You do have time. Next slide, please. So there's some good news, there's some bad news, and there's more good news. The good news is you might not be covered at all. And many of you listening to this program, and this is a program for U.S. federal government contractors, many of you may have looked at the way I defined the scope of this and said, that doesn't, I am not handling any EU data. I have no interest in that world. I'm not covered. Good news, you're not. That's bad news. It's entirely possible you are covered, even if you don't think you are, because if your business touches on EU data in any conceivable way, you are almost certainly going to be covered. And it's especially as you grow and expand, as you partner with other businesses, as you share data across countries and jurisdictions, you are likely to be covered. But back to more good news. There is more good news. If there's bad news and you are covered, another big thing you're probably all aware of is you're probably very aware of that you are already required in the United States by the United States federal government, by the Department of Defense, and by other federal agencies to do a lot of this stuff already. For example, can you go to the next slide, Jennifer? So the GDPR has it wasn't written this way, but incidentally or not, has much relationship to the DoD's cybersecurity regulations and many federal agencies, PIAs. I'll just touch on this without going into a whole lot of detail. For example, the DFARS cybersecurity requirements under sections 7012, 252.204. These cover applicable to DoD contractors handling controlled unclassified information, COI information. If you are, anybody doing business with the DoD is intimately aware of the compliance deadlines for these at the end of this year, not May next year, December 31st, 2017. And under the DFARS, there's specific reference to the NIST cybersecurity framework from 2014 and this NIST special publication, in particular 800-171. And also other agencies of not just the Department of Defense, but non-military agencies applicable to, particularly where you're handling operating any systems or any services on behalf of the federal government, you are almost certainly going to be subject to similar FAR requirements for cybersecurity or PIA requirements from those agencies. And I will also mention that the DFARS 252.204-70212C, and I said that very quickly, requires a 72-hour reporting of cyber incidents to the DoD. That is identical to the GDPR breach notification requirements. I also want to mention, can you go to the next slide, please, Jennifer? Mary Beth Bosco of Holland and Knight, and I don't know Mary Beth, but I am familiar with her presentation on through the same webinars that Jennifer's group is putting out. A few weeks ago, put a program up called "Are You Prepared? DoD Cybersecurity Deadline," which is very good on this topic. It goes into a lot more detail and a lot more confidence, quite honestly, than I can offer on the specific topic of cybersecurity regs and its relationship to, well, not so much the GDPR, but cybersecurity regs as relates to federal contractors. I mentioned that as a great reference and a great analogy to what we're doing here under GDPR. And I mentioned this as the last point on the good news category because much of this is stuff you're almost certainly already familiar with, and much of this is stuff you're already very much implementing already, and should be. Okay, next slide, please. So just what does the law require? I have 3 slides on this. I just want to touch on a couple things. So in the first slide, there's quite a few compliance requirements under GDPR. The first slide here, these 3, privacy, impact assessment, data security measures, and data breach. I actually just touched on these because these are requirements under the GDPR that should be very familiar to U.S. federal government contractors, as I just explained, due to the DFARS and the FARS cybersecurity requirements. So, for example, privacy impact assessment. If you are conducting any high-risk processing, high risk as defined in the GDPR, which is processing using new technologies or of a new kind, or based on a long time elapsed since the last time you did it. If that's the case, you are required to do a PIA, privacy impact assessment. I mentioned a moment ago that all federal agencies under the E-Government Act of 2002 are required to themselves conduct PIAs. It is entirely possible that subcontractors to those agencies under certain contracts will currently also are and will be also required to conduct PIAs in connection with data processing. I won't go into so much detail on that, but there's some right here. I'm also have lots of follow-up information I could send to anyone who is interested. Data security measures. We talked about the DoD's DFARS. GDPR defines it as appropriate technical and organizational measures. that's a very loose standard. I will mention also that DFARS cybersecurity defines it as adequate security. DFARS adequate security simply refers by reference to NIST 800-171. I include an article at the end from the IAPP, that's the International Association of Privacy Professionals, specifically calling out NIST 800-171 as a compliance item under GDPR. Just to mention, again, this is the tie-in, and it also points out an irony in that the one of the compliance mechanisms under GDPR, which is definitely a European, not an American law, is referenced to a very well-regarded American data security compliance mechanism, NIST 800-171. So again, you guys are almost certainly familiar with these. Another one outside of the contractor world, but is also recommended with GDPR, which is ISO 27001 or 27002. Either of those is, to be clear, GDPR does not specify either of those or anything else, unlike DFARS. But GDPR does provide for accreditation bodies, and there will almost certainly be organizations empowered by the various European governments to accreditate organizations' compliance with GDPR. They will almost certainly reference your certification under ISO 27001, 27002, or the NIST framework. And I also mentioned the data breach notification, 72 hours upon discovery. If you are a subcontractor to a controller, and if you are a processor to a controller, the obligation is actually, the notification is to the controller, but it has to be immediate. You did not previously have that obligation under the law. You may have had it under a contract. Next slide, please. This is the second of three categories of items that are required under the law. These things are new, but they shouldn't be terribly surprising, and some of them are they're entirely commonsensical. Data protection officer, so it's a DPO. If your organization has 250 or more full-time employees, you are required to designate an employee, or it could be an outside consultant, responsible for monitoring and protection of personal data. Privacy by design and by default. This is actually very important. The concept of privacy by design is not a new concept. It's been around for, probably 20 years. In the development world, this is the, maybe not the first time, the first prominent time it's implemented directly into a data privacy and data security law, requiring that basically privacy be baked into development, baked into systems, baked into processing. Record keeping requirements. Again, most laws on data privacy and data security have record keeping requirements. These are very stringent in terms of records of processing activities, and these failure to keep these requirements are used in, or compliance with these requirements are used in determination of penalties for breaches, the harsh penalties I referred to, the 2% and the 4% in the prior slide. And then data transfers outside of the EU. You may be familiar with the EU-US Privacy Shield, which replaced the safe harbor or standard contractual clauses. These things are, it's unclear if they're still valid, or they're still valid. The Privacy Shield is still valid under the current law. It's unclear if this is going to be valid under the May 2018 implementation. So the question is, and it almost certainly will be reduced validity. And for US companies, it used to be you could simply certify your compliance with this lesser as compared to the EU directive of compliance standard. Now it's almost certainly going to be compliance with the full GDPR if you are governed by the jurisdiction of thresholds of the GDPR, that is handling, processing, storing, monitoring data of EU citizens' personal data. Okay, next slide, please. And the third third group of items, and these are new, and these are probably the most challenging to comply with, but also the most important. That is consent of data subjects, that would be individuals, and rights of the individuals. Consent meaning, in most cases, you are going to have to obtain consent from individuals to the collection and use of their personal data. That is a game changer in many industries. You've probably, if you are working in that world, you've probably heard about how the Googles of the world and advertising technology industry are trying to adapt measures and technologies to be able to comply with this. Being able to get explicit consent from individuals to collection of data when that data has to do with highly sensitive information. But even if it doesn't have to do with highly sensitive information, consent to the uses and specify the uses is required. There are limited exceptions. And then the back end of that is the rights of the individual data subjects. You're probably all familiar with the Google case from a couple of years ago in Europe, which came out with the right to be forgotten. That's one of these rights. It's known as either right to be forgotten or the right to erasure. These are all rights an individual must have the ability, and you must make that ability available to that individual to access through your systems their data and what you're doing with their data, and to see it and access it and correct it and remove it. Those are, and going back to the idea of privacy by design and default, building those capabilities into your systems as a GDPR compliant company is absolutely critical to compliance. Okay, next slide, please. Just one or two more things. So some obvious questions just to wrap up will be, what should I do now? And does this mean that US companies can't receive data from the EU? On the second question, no, it does not mean that you cannot receive data. It just means you will have to comply with these obligations, which are more now stringent than previous. On the first question, what should I do now? There's quite a few things you should do now, but and I said this is not supposed to be a compliance guideline, but I will offer you this. Please, next slide, please. So before I get into this graphic, which came from a UK company called iStorage Limited, which offers compliance services under the GDPR, I will mention a couple things to focus on, and some of those are covered here. Privacy by design, I mentioned. There's four of the 7 or 8 compliance areas I touched on before. There's 4 I would particularly focus on. Privacy by design and default, that's baking privacy into your systems, and security. The consent requirements, the record keeping requirements, and the incident reporting or breach notification. It's not just a question of you must notify applicable data protection authorities on 72 hours. You also have to make sure your company has procedures for doing that, and training, and has staff knowing what to do, when to do it, and how to act on it. So taking a look at this, this slide from iStorage, 5 steps. I mentioned data protection officer. Step 1, resource and planning. If you employ more than more than 250 people, you need to appoint a data protection officer, someone with authority within the organization to be responsible for and to report to outside authorities, government authorities, on data privacy. Number 2, information mapping. I didn't get into this because the GDPR doesn't specify, there's no requirement to map data. What it does, though, if you get to the point of compliance with record keeping, you are going to have to evidence how you look at your systems and how you complied. So taking a look across your organization to see the sources and uses, just like a a financial statement, the sources and uses of data instead of money, within where it comes from, who it comes from, how you get it, what legal authority or consent you have to get it, and so forth. Looking at that inventory and then putting that into a physical picture map should show you where the gaps in your compliance are. Number 3, data minimization. If you hold personal data that you no longer need to hold, cull it now. I mentioned collection of data that is not used. Before I mentioned, a client had mentioned this to me. GDPR does not allow you to, well, you are allowed to collect it, but if you are not having use for it, you must remove it from your systems and implement steps to do that as a standard procedure. Number 4, make sure that your technology that you buy, develop, and implement is GDPR compliant. I'm talking about new technology and new systems. And then number 5, contracts. So very few, with your customers, with your vendors, with your primes, with your subs, you have these obligations, and these cross obligations must be implemented. Anybody you subcontract services to or from is going to require you to implement them. You are going to be required by your contract partners, both on the senior level and the junior level, the sub level, and the prime level, to have obligations spelled out and liabilities spelled out and specified. Okay. As I mentioned before, I had a list at the end, and this is the end of a number of compliance resources. There's a zillion of these. These are, well, the first one is actually from the a working party of the European Union on the Article 29 is one of the data consent requirement, I think. I'm sorry, the DPIA, the data, the protection impact assessments. But looking at the Article 29 Working Party, it's a very good resource for how the government and the enacting bodies of the EU are thinking about some of these compliance obligations. And then a number of other resources here that I may have mentioned. And the last one, how NIST security controls might help you get ready for the GDPR. This is from the IAPP, a very, very good organization. These are ones that I found good. There are many others. I can send others as well. And as you can see, there's quite a bit here, but I wanted to give you an introduction. I think I've done that. And please feel free to contact me by telephone. There's my phone number, or email. I'd be happy to speak, email, and follow up. Thank you, Jennifer, and thank you to all of you for attending.
Thanks, Andy. Great information. If anybody has questions, please contact Andy directly. He also did mention a YouTube video and presentation that Mary Beth Bosco from Holland and Knight did that's on our website. That was in our series a couple of weeks ago. You can find that under the webinar section, under the schedule. All of the webinars that have been recorded are listed there, and they're segmented by topic. Tomorrow, we're going to cover the management section of the proposal. Week 9 and week 10 will be the final weeks in this series, and we're going to be discussing in more detail GSA schedules, 8A certification, and sole source contracts. You can find the full schedule on our website. Thanks again, Andy. Thanks again, everybody who was able to join us today.